Hey, Translash fam, welcome to the Translash podcast, a show where we tell trans stories to save trans lives. Well, today the big story, of course, is from the Supreme Court on these two trans sports cases, and they were bundled into one case, one out of Idaho, Hecox versus Little, and another out of West Virginia, Becky Pepper Johnson versus West Virginia, where they were deciding essentially whether or not equal protection clauses, both in the law under something called Title IX with regards to equal access to sports in schools, and also the equal protection clause of the Constitution itself applies to trans people in these cases. And they ruled that they didn't in both of those cases, sadly. Here to unpack what all of this means, because it's both complicated and simple, as can often be the case with the Supreme Court, is for the second year in a row, Chris Geidner of Law Dork and so many other things, New York Times, just kind of a legend in Supreme Court reporting, who is taking time out of an extremely busy day, probably the busiest day of the year, besides running down the steps of the court after a case, to be with us to help unpack it. And Chris, thank you so much. We both have to join from home
Yeah,
today because there's too much going on. We can't be anywhere else.
so glad to be able to talk with you today. I mean,
Um,
wish it wasn't this discussion, but always glad to get to see you.
okay, so before we get into it, what are the confusing things about, like, because we normally say the court voted, 6-3, 5-4 in a case. But this case, and this has implications for our audience in terms of, how they perceive this win or loss.
Yeah.
Depending on how you look at it, it's either a 6-3 case, meaning all of the conservative judges and the three liberal or left leaning ones, or 9-0, like everyone. So, first of all, like, how would you characterize the vote, and why is there this like vote split on these
Yeah.
trans sports cases?
It was a difficult opinion to look at. If you look at my initial posts on Blue Sky and Twitter and on at LawDork, like I didn't even say the vote count. Because it was that confusing, and I mean it's most important for me, especially right there at 10 in the morning, is I'd rather not say something than say something wrong.
Right.
But I mean, really coming out of today, it was a 6-3 decision. There were a lot of technical things happening in the case that led there to be all sorts of technical wording of the court's specific procedures that led to it's a partial dissent is what it technically is known as. There are sort of regrettably three main reasons for that. I wish I could even just say it's one. Um, the first is this issue about whether Hecox's case was moot. She had said
The Idaho case.
the Idaho case. She had said, I'm not planning on playing sports ever again. I'm disclaiming that. I will not do that. And so she suggested that her case was moot. The court put that off, and the majority today said, we don't think it's moot. But in their dissent, Justice Sotomayor said in a footnote, like, we think that her case is moot, so we're only addressing Becky Pepper Jackson's situation in our case. And there was no real reason why they couldn't have considered her case moot, because they still got to resolve everything they wanted to resolve through Becky's case. And that was also sort of Sotomayor's second point. So that's one confusing element of it, is that the majority did decide both cases and they consolidated them, but technically the opinion from Sotomayor was only addressing the Becky Pepper Jackson's case. Second, there was this issue of how the Title IX case was before the court. The Title IX, the Education Amendments of 1972, and then 2 years later, a thing that became very important here, which is known as the Javits Amendment, which specifically included instructions about sports, sex differential, reasonable differences based on sex in sports accommodations. Um, and in bringing Becky Pepper Jackson's case, which was the only case that brought the Title IX case. The Lindsay Hecox's case didn't even bring a Title IX claim. But in Becky's case, they didn't challenge for the purposes of the case. They weren't saying it couldn't be challenged. They weren't saying it's not an issue. But for purposes of the case, they weren't even challenging that Title IX's definition of sex refers to biological sex, because they were saying even if you assume that, this still doesn't pass Title IX. But what all 9 justices said on today's ruling is that in light of that concession, basically we don't have anything to debate. And if you're going to acknowledge that Title IX's definition of sex is biological sex, if you're not going to dispute that, and if you're going to say that the Javits Amendment uses the same definition, and if you're not going to challenge them as being illegal or unconstitutional laws, then that isn't really debatable. And so because of that, the Title IX case, basically they said, like, Becky, you wouldn't have won on that in light of those concessions. But I do want to note one different opinion there that I think is, you'll be seeing me write a lot more about this. It was kind of incredible. Justice Jackson wrote a separate opinion. She had joined Justice Sotomayor's dissent along with Justice Kagan, but she also wrote separately, and I want to actually pull this up. She said, this is astounding. Like I truly, like, my heart is full for the future. And I think everybody needs to read pages 2 and 3 of Justice Jackson's opinion. She says, there is reason to doubt the soundness of the concession that Title IX's reference to sex means only sex assigned at birth. She is literally laying out there is a path for the future here. And so I think that that's important. So that's why it's a partial dissent. But then when we get to the equal protection discussion, it's just an all-out dissent. Justice Sotomayor explains they applied equal protection wrong. They applied equal protection law under sex wrong. They applied equal protection law as to transgender status. They said we don't even need to get into that, but they clearly applied that wrong. And then they said, in light of this specific case, the Supreme Court did much more than it needed to do, because what the Fourth Circuit, the lower court, had said is, we want to send the equal protection part of this case back to the district court, because there are so many factual issues that still need to be resolved to understand if, under intermediate scrutiny, which is the level of scrutiny that sex-based discrimination gets, whether West Virginia's stated rationales about fairness and safety actually are justified in Becky Pepper Jackson's case. And essentially, Sotomayor said there are no facts. Like, the court is deciding this in a vacuum of facts, and that's not the way that we do things. And so they sort of went out of their way, I think, in Justice Sotomayor's opinion to say, like, we're not deciding how this case will turn out. We're not saying that Becky would win. We're saying that the Supreme Court, the majority, went way too far today. They got equal protection law wrong. They got sex discrimination law wrong. And they got how it should be handled in this case wrong, because they should have just sent this back down to the lower court to actually resolve these factual issues that need to be resolved when you are dealing with intermediate scrutiny.
Yeah, I mean, I think so. All of that is a lot of the reasons why there was this technical conversation about what the vote count was, and you touched on some of the important sort of legal arguments that kind of went through, kind of getting all of them to that particular place. But let's just take a step back and talk about what the ruling actually said, right? The ruling said, essentially freezes the status quo. It says that states may decide
Yeah,
may decide that biological sex is a reason to exclude trans people from sports. That is currently what 27 states do. The court said that those 27 states can do that, and the 23 states that don't allow for that discrimination can do that under the existing law. Like, it just kind of freezes
what
the
Justice
status
Kavanaugh
quo.
dropped, his first footnote in the opinion says, this case does not address whether states can. We're issuing no ruling on that.
Right. And so, like, I think that that's just it freezes the status quo. It says where things are where they can be. We're not ruling one way or the other. But one of the things that really struck me as I read it is, it's like what they always tell you about Supreme Court cases. It's not only kind of what the decisions are, it's the rationale for the decisions and what they are teeing up. And one of the things that really struck me about the majority opinion written by Kavanaugh is the degree to which, it relies upon, I would argue, trans erasure to make its argument. I mean, it kept using this phrase, biological males who identify as female, right? And that's just not, that's not, yeah,
he never used the phrase, even when he did. This is a great point. I've got my art. I'm working on my article. He never once used the phrase transgender girl or transgender women. Even
that's right.
when it was trying to be a softer, gentler anti-trans ruling.
That's right.
Because he did talk about, like,
We sympathize,
we
essentially.
sympathize with these people. But even when he was doing that, he would talk about transgender. It was a very subtle thing, but he would talk about transgender athletes, transgender individuals, transgender student athletes. But he never once said transgender women or transgender girls, even though that's what the entire case was about. So
That's exactly right.
I think but he did use more than a dozen times biological males who identify as women, or
That's
biological
right.
males who identify as girls.
Identify as female, and it was like literally in the first sentence of his opinion. And one of the things that I think that does then, like, and they were, and he there's a lot of things that he addresses, like these anticipating future arguments. So if we were to say that trans people were a protected class, right? And a protected class for viewers are a group of people who experience discrimination and therefore are entitled to a higher level of scrutiny under the Constitution because of that. He was saying, even if we applied that, it wouldn't mean that, in this case, that trans people, would be considered to be, that the ruling would be different. It's like anticipating these things that are coming, but more to the point, like, if you say that, like, biological males that identify as females, if that's the ruling in this opinion, and then you're going to apply that to other opinions, how then do you recognize and rule in favor of trans individuals. Like
Yeah,
it seems to be really hard to do. I don't know how that happens.
he like this is also obviously building on Scrimetti last year's ruling. And the problem, and this was another thing that Justice Sotomayor pointed out, is that one of the big things last year was the fact that Chief Justice Roberts, who wrote the majority opinion, insisted that the law, neither the Tennessee law at issue there, neither classified based on sex nor transgender status. Here,
That's right.
though, that wasn't the case. Here, everybody agreed the law classified based on sex. And because of that, this was one of those special cases, intermediate scrutiny, which is this heightened scrutiny under equal protection. And because of that, it should have gotten, it should have been more difficult to pass muster. And so in that sense, the biological sex isn't necessarily bad in and of itself. It was how the court applied it and the fact
Right.
that, but beyond outside of the legal thing, I think you're absolutely right that the problem is you heard nothing about transgender girls. You heard nothing about the reality of the situation in the
That's right.
majority's opinion. You heard about biological males. And there were a lot of times where he essentially just shorthanded it to, or was discussing biological males, because he kept talking. There was this big issue about whether or not, under intermediate scrutiny, which is what sex classifications get, you can consider subclasses. And essentially, what Kavanaugh was arguing is that Becky Pepper Jackson was asking for the court to say, yes, this might be constitutional against a cis male who wants to join a girls' team, but it's not constitutional as to me. And so that subclass. But then he sort of used the argument against the necessity of these bans against trans people because he essentially said the subclass is too small. And
That's
if
right.
the class is too small, so if there aren't very many trans women trying and trans girls trying to join sports teams, essentially they can't ever succeed in challenging the law. And so Justice Sotomayor in her dissent, like basically this is where she explained that he was using this subclass discussion to essentially rewrite equal protection law. And that I think is the real question about where this goes and how it makes things difficult moving forward is like if a transgender person is making a sex-based claim, are they going to need to prove that it's a huge group of transgender people that are going to be affected? Which now you might be able to in employment. Like, well, employment's not an issue, but in something that all transgender people would be involved. But it does make it basically just makes a bungle of equal protection law. And I do think that that's a combination of sort of the careless way, and Sotomayor does point this out, that Kavanaugh applied Scrimetti to this case because Scrimetti was decided under rational basis, which is the lowest level of scrutiny, because they found that it wasn't a sex classification. It wasn't a transgender status classification when they were talking about the Tennessee law. Now, that was wrong. Obviously, Robert's opinion was horrible. We've talked about that before. But That's really important because that meant that the law and all of the analysis was under this rational basis, which basically just means the state needs to give a reason, any reason. And as long as it's not irrational, it passes muster.
They can discriminate. Yeah.
Right. But that wasn't the rule that should apply when you are dealing with a sex classification like everybody acknowledged here. And so, in that sense, Skermetti should not have been quoted
Yeah.
today.
Yeah.
It,
And I think
it,
there's,
it
yeah,
it
I
was,
think there's like a paragraph from Scribetti
yeah,
that's actually
there
quoted.
is at one
Yeah.
point that he literally just transfers an entire paragraph. Uh,
Yeah.
and so I do think, I mean, the second reason is bluntly Justice Kavanaugh, I'll say it as nicely while we're on air. Justice Kavanaugh is not the top of the class on the Supreme Court. And so I think it giving him this opinion at the end of the term, while they're rushing out opinions, it probably was a little more sloppy than it should have been. And I do think, particularly Justices Barrett and Chief Justice Roberts are going to have to deal with cleaning up some of this going forward.
Let's talk about, in the remaining time that we have, about going forward and some of the implications here. And some of this flows out of the oral arguments that we sat through. I mean, you today are dressed more comfortably than I am. I'm wearing, actually, this is a suit that I wore the day of the oral arguments. Someone asked me like what it was like being there, and I was like, hard, and they were like, as in, the arguments, and I was like, no, the seats. The seats are really hard in the court. But one of the things that I think in terms of where we're going came up in some of those oral arguments where we could go. And I just wanted to throw a couple of things that stand out to me and see, as a person whose job it is to stay immersed in the court, what you think. One is this idea of is it time for us at a certain point to create a special class for trans people, right?
Mm-hmm.
Like, do trans people need to be designated as a protected class? And Amy Coney Barrett said, we're going to have to deal with that at a certain point, right? Like, it's just my instinct. We can't keep ruling on these cases one at a time. That's one thing. And that has big implications because if they rule that trans people aren't in a case, that's a huge setback for trans rights and for trans equality. The second one is this question of numbers driving rights. And this was part of the argument that actually one of the lawyers for the state made during this particular case, during the particular oral arguments. And it's clearly one that Kavanaugh picked up in his oral arguments, but that has like very serious implications for the future, right? Like, if we get into a situation in America where there's a size threshold for the application of rights in the Constitution, I mean, that's pretty dangerous. So, I mean, the road here.
This is where we got on that subclass issue. And so I think that does have important ramifications for sex-based discrimination. That wouldn't have ramifications for if transgender status can be a protected class.
Okay.
That is important. That was all a discussion about, like, is it really a subclass? How small are subclasses? Could you get it down to a subclass of 3 people? That was all about in the sex discrimination context. If you have a full-fledged classification that is actually based on transgender status, then that would have protection. I do think that, like, at the arguments, and I think this is a credit to Joshua Block from the ACLU and Kathleen Hartnett from Cooley, who argued for the other plaintiff, that it really was like from Skermetti to those arguments, it was a different situation. I think there was aside from Thomas's awful concurring opinion today, which is just horrible anti-trans vitriol for no good reason. He didn't need to do it. Um, it like nobody joined him. He didn't need to do it. He wasn't even advancing any real legal principle. It was just
That's out of
like
spite.
he wanted to do it.
Yeah.
But in some ways, I actually think that that's also a good sign. He did
Hmm.
feel like Kavanaugh was being mean enough. Um, and I think in my story about the arguments, I wrote about the fact that it was a nicer argument than we had gotten in the Tennessee in Scrimeti. And
Hmm.
I think there is an acknowledgement, particularly from the younger justices, that like, ooh, maybe this is looking a little bad. Like we're going in a bad direction about how we're talking about and treating these people. And I think that that came through in Justice Kavanaugh's opinion in a way that while certainly, I mean, obviously on the merits and as to some of that, those language usages that we've already discussed was not good. Like we've also talked about the fact that he did, like he ended it by talking about how like
Yeah,
trans people wanting to play sports shouldn't be denigrated, how
that's
they
right.
have good reasons for wanting to do this, how we do understand why they want to do, like he even at one point said like the dissent doesn't have uh full ownership of the ability to be sympathetic to these people, which I do think is notable. And I think, and he also, I mean, like, he did repeatedly talk about the fact that this was just about the sports context. And when we're talking about
That's
going
true.
forward,
That is true.
um, I want to just read this
No,
one
that's true.
section when he is talking about it. He specifically says, sports are different from, say, a typical employment or educational opportunity where equal
Hmm.
protection often may require that the government generally treat an individual without regard to the individual's sex. And he says in the sports contract text, by contrast, blah, 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 goes on. But like that is in the majority opinion. And the important reason why that matters is when he says, or educational opportunity actually is the fundamental protection of Title IX.
That's
And
right.
that is, and Sotomayor really picks up on this in her statement, even about Title IX, that what she says is we weren't talking about Title IX. We're talking about Title IX because of the Javits Amendment in the sports context. And please allow us an opportunity. Please, lower courts, understand this doesn't mean other situations, even under Title IX, wouldn't be different. She more aggressively says Bostock, which was the earlier decision that said the Title VII protects sex discrimination ban, protects based on sexual orientation and gender identity and transgender status. She said Bostock does have this decision does not mean that Bostock doesn't have things to say about the broader interpretation of Title IX. And so I do think that, and both in Kavanaugh's opinion and in Sotomayor's opinion, we do have a very strong view that depending on how things go, there could be an effort to really cabin this as sports. Which obviously has its immediate effects, has its stigma related effects, has the concerns that we were talking about the language used in the opinion. But it, this was not the opinion that anti trans forces wanted. They wanted a broad opinion that would immediately apply to all of Title IX, that would apply to all equal protection, that would apply to transgender status, and they didn't get that today. And I do
But
think
didn't
it's important.
but didn't in the court, it was one of the lawyers, I think Kavanaugh asked, you know, about like do we have to rule in a way that is sweeping, and one of the lawyers for the state said no, like you
Right.
can rule this in a way which is narrow, which means that they wanted they wanted to swing for the fences, but they would accept a more narrow ruling
Well, the
because
state,
it's a stepping stone.
I mean, the states are somewhat different than some of like ADF or something. Like
Right.
Idaho was much more closely connected to ADF. They were represented
100%.
by ADF, but West Virginia ADF had intervened it by a separate with a separate party.
Mhm.
And so I do think like sometimes the at the end of the day, a lawyer's job when they're before the court is
Is
to
to
win
win the
that
case.
case.
Yeah,
And
yeah.
so when Justice Kavanaugh, who clearly they knew could be a swing vote, was asking them, can we rule narrowly? Um, even the state's lawyer, even Idaho's lawyer was going to say yes. Like, if you need to today, do that.
That's right. That's right. What So I think that this issue of stigma, and this will be among my last questions. I mean, I think that there are now two cases in which they've ruled against the equal protection of trans people. And there is a way that they are aware that these cases are not only don't have like only technical legal limitations, right? They also set the tone for how groups of Americans are treated. Like
Right.
they understand that, and they understand that they're setting the tone, as you said, for stigmatization amongst trans people. And I'm wondering if this this tension that you indicate is growing in the court, like what that means for the military case and the passport case. So that we have two more Supreme Court cases that are going to rule on trans people that we know about. Like, what's your sense
Well, we
of?
don't know. I mean, the court hasn't taken either of them.
Oh, I thought they had taken
No,
those. Okay,
they had ruled negatively on the shadow
on the
document.
stays. Oh yeah, yeah,
Yeah.
yeah. That's right. Okay,
But they're working through lower courts and appeals courts. Um, but yeah, I mean, you're right that I mean, they eventually will need to be resolved. Um,
right. They have a sense that they're headed that way.
yeah. I mean, I think that I mean, I don't feel good about either of those, given where we're at on, I mean, specifically, ironically, neither of them do I feel worse about those cases because they are the military and because they are about passports, which is the administration argues is about our their interaction with foreign affairs,
Oh
because it
right.
is the way that we present Americans present themselves outside of the country, and so I actually think that the given the way that the court has been deferential to all administrations on those issues, but particularly the Trump administration, when you look back at Trump versus Hawaii and look back at some of these immigration cases that we heard this term, it is putting birthright citizenship aside, which was just its own case. Um, the court is very comfortable giving the Trump administration a very, very wide berth on anything that the Trump administration comes to them and says, oh, we're talking about international things. Um, Particularly when they're non-economic international things. Um, because the tariffs, well, that was
Right.
uh,
Business. That's right.
And so I mean, as to those specific cases, I don't think that this decision is outcome determinative of those cases, but I think that when you combine the overall sort of view of the court on trans issues with the overall view of the court on military deference and foreign affairs, I wouldn't be excited about the chances of the court shifting when it comes to that. I do think the passport case could get complicated when it comes to the different levels um, of because of the different ways, like if a person lives in a state, like it's really multiple cases. Because if a person lives in a state where birth certificates can be amended and theirs has been, they have no identifying documents that show them as the sex that they were
Right.
assigned at birth, then that is a different case from, remember, the policy under the Biden administration was self-ID. And so, like, that's obviously a different legal case from a person who just wanted to submit an identification to the Social Security office or the passport office that they wanted a male passport. But at the but yeah, at I've rambled enough about it. We'll get it is there are complications in the implementation of that that could lead to a more narrow ruling. But I honestly thought that when the stay request was at the court and we didn't get any sort of nuance from the stay ruling.
Yeah, I mean, there's so many complications there. What about people who have had, because you've been able, you've been able to actually change your gender identity on passports for actually decades,
Yeah,
right? It's just
no,
that
that's the thing is that
it's the rules of doing so change. So then where do
I mean,
they
the
draw
rules
the
kept
line?
loosening, and then
Right.
Trump took it back to beyond where it had essentially, there had never been a rule.
That's right.
It just went from like it wasn't done, but then eventually, when somebody tried, there was a process, and originally it
That's
was
right.
like multiple, you need gender confirming surgery, all of this stuff needed to
Exactly.
happen. Then it went to a lesser standard that was more presentation and care, and then it went to the self ID, and so the Trump administration went back further than it ever had. To a point that we've been discussing, though, and I think this is a part of it. I actually do think the stay ruling on the passports case was a low watermark for the court. It was, I would argue, the most anti-trans ruling that we've gotten from the court.
Mm,
It was a very bad uh, shadow docket decision, not signed by anyone, and so it's a little more careless, I think, because they're not accountable for it. And that's why I hate the shadow docket and always talk about it and write about it. But I do think that there was a lot of pushback to that opinion because it was so dismissive of the harms. And I believe it was Sotomayor who dissented there. Um, and it really did talk about the how the court dismissed the harms that would be caused by staying the injunction. And I hope, dreaming against for the best case scenario, is that that was sort of a low watermark. There was some effort from somebody on the court or somebody in the courthouse to be like, hey, justices, like these are real people, and um, you need to think about that. And we did kind of see that slightly gentler argument in January. And then we got this Kavanaugh opinion today, which obviously was not the right ruling, had these problems we were discussing. Um, but certainly Gorsuch's concurring opinion attempted to be that same sort of gentler, softer like Kavanaugh, and it was only Thomas's opinion that was really an anti-trans opinion. And nobody joined him. Like even Alito didn't join him. And so I I hope that the younger members of the court are open to a more full understanding of transgender people's lives, um and that is something that with time could change, and that's something you remember that did come up at arguments that
Mhm.
Justice Kavanaugh had been asking had asked Kathleen Hartnett about that
Mhm.
it seems like your argument is that the more that people get to know trans people, the better they'll think about them. Um,
Mhm.
maybe that happened. Who knows? I mean, we don't know what happens in the real world. Like maybe one of the Republican appointees like met a trans person and is starting to learn that process that many of us learned many years ago. But hey, if that conversation is getting Kavanaugh to start learning, that's a good thing, I think, in the long term, and maybe will eventually lead to a change as the court moves forward. I mean, it's not a good day today. This isn't a good decision. It has a lot of bad things. It has a lot of bad things for equal protection consideration. Um, but it is a reminder that this is not the last case, and that there are many fights to be had that could be more successful.
Well, the idea of like getting to know trans people and it changing the way that people feel about trans people is actually something that we at Translash believe wholeheartedly. So hopefully that process is working its way through. And I just want to express my appreciation again for you coming on today. It was a very long day, very complicated opinion and opinions, because this wasn't the only thing that you've been writing about today. And as you say, there's a long road to go. And I see you on that road, so I know I'll see you again whenever the next trans case goes before the court. But thank you so much for coming on and helping us break it down today, Chris. Really appreciate it.
Thank you so much, Imara.
That was Chris Geidner, who is Dork, founder of Dork, which you can find all across social media. Please do also go to the website and subscribe to the site and the newsletter. And you can dig deeper into the history of anti-trans cases at translash.org through the anti-trans hate machine, which focused the very first episode of the very first season, focused on the Idaho case. And that of Lindsay Hecox, and then throughout all of our other reporting for throughout the years. Again, thank you all so much for joining us this afternoon, and we'll see you soon. Take care of yourselves.